sorry, yes. And therefore, I think this is the objective of this event is a little bit for the Commission to clarify what are their objectives they're seeking in terms of information, in terms of feedback, and then, of course, for the civil society and academia to fit in this process and to somehow express their perspective, their views on the different topics. So we structured this conference in 3 panels. The first panel, which is pretty big panel, I think, will be discussing about the question, is it really a de facto public interest standard? Are we moving towards a de facto public interest standard? Should we move towards a de facto public interest standard or not? The second panel will focus on the social and environmental sustainability concerns, particularly looking to the effect of mergers on labor markets and labor more generally, but also environmental sustainability. And the third panel, we wanted to make it a bit more practical to the extent that we have a number of cases in the food industry, a number of mergers have been assessed by the Commission the last few years. I think the food industry was extremely important in moving forward different agendas. For instance, the innovation, theories of harm, innovation spaces were basically developed in the context of some of the cases of the mega mergers in the food sector we had back in 2016-17. We have the Banch-Viterra merger more recently. Other mergers have been also focusing on the food sector. And there, I think the food sector is an interesting one because you also have environmental concerns. You also have social sustainability concerns to the extent you have farmers. You have a bargaining kind of power models that might be of interest in the assessing the merger. So therefore, I think it's a quite interesting case study to explore, how far the Commission can go in integrating this socio-environmental sustainability concerns, what type of form they might take in the context of an innovation theory of harm, for instance, and more generally, how concentration and bargaining power in buying markets might be of interest in this context. So we planned this session to be quite interactive. So obviously, we have a number of speakers. We have a scenario for each of the panels, but the idea is to leave some time to take a few questions and comments from the floor, so as to enable us to move forward the discussion. So thank you very much, and I pass now the mic to Simon Holmes, who was chairing the first panel.
This panel asks if we're moving towards a de facto public interest test in EU merger control. It shows how long I've been doing this, doesn't it, if I say EC by accident. But that raises the question, what is a public interest test? It's different things to different people. Is it part of competition law, or is it something outside it? And there are various ways of looking at this, and just to throw out a few before we have more specific discussion. Is it some sort of guiding principle that should be applied when applying competition law or merger control? Perhaps analogous to Commissioner Vestager's increasingly frequent references to a concept of fairness. Fairness, public interest, they're not a million miles away. Or is it similar to what the Court of Justice said when it referred to public interest in describing the fundamental objective of Article 102 in the European Super League case? Or as is explicitly written into the South African public interest guidelines on merger control, about which we'll be hearing later. If this is the case, then clearly I would suggest it is very much part of the competition analysis in merger control. Alternatively, though, there is a different approach. Is it something different to competition law, to be applied in parallel or after the competition analysis has been done in a merger control context? In this context, I think of the idea of legitimate interests under Article 21(4) of the merger regulation, with things like plurality of the media, national security, etc., and its equivalent under national law, national competition law, the public interest test, which exists in many different countries and is sometimes more accommodating of public interests than the EU merger regulation, at least officially. For example, in the UK, you have, in our public interest possibilities, you include the stability of the financial system. But actually, I put those two as if they were big alternatives. The reality is much more complicated than that. The real world is more complicated than that. The EU's merger working group in 2016 found that 12 EU jurisdictions, which had a wider public interest considerations, which could be taken into account. But sometimes they were part of merger control, the merger assessment itself, and sometimes they were somewhere else in the wider decision-making process. So that doesn't really clarify things in any way. And even whether it's part of the competition analysis or outside it, you can't say you could determine that by reference to the particular interest concerned. For example, if you take something like sustainability, environmental sustainability, or employment issues, which we'll be looking at particularly in the next panel, sometimes they fit nicely into a competition analysis, at least in my view they do. But sometimes people would say, and I would certainly accept, it's perhaps more appropriate to deal with it outside the competition analysis and deal with it explicitly in some sort of public interest test. So you can't easily resolve the issue that way. It also changes over time how you look at these things. If you take the UK, and I take the UK because I've been involved with it for some 40 years, we used to have public interest considerations in our competition analysis, and that included things like employment, it included things like regional policy, but over time it got narrower and narrower and narrower until the government said explicitly, well, actually, we're only really going to take into account competition concerns, and now we have a neat split. Only competition for the competition authority, unless the minister interferes, etc. And then there's the question of who deals with it. And that may depend on the answer to the other questions. I think in one country, Portugal, it's dealt with by the competition authority. I think in other countries, where there are public interest tests explicitly dealt with, they're dealt with by some other authority. But of course, in reality, some of those public interest issues are mixed in with the competition analysis, and therefore they're dealt with by the competition authority. So there's a few general remarks. I want to turn to our panel now. Now, I'm going to assume that you know about our speakers. I hope you've read the programme. You won't be here otherwise, so I'm not going to say a lot about my colleagues. I'm also going to ask, before I move to just tell you a little bit about the structure, I'm going to assume that everybody here is speaking in a personal capacity, and if they're not, please say otherwise. And I'm also going to assume that nobody has any conflicts of interests or anything which they should be declaring, which you may do, in which case, please declare them now. Okay. I thought it would save time if we did that collectively, since we've got relatively little time. Now, the way we're trying to structure this session is that Danielle, on my your right, is going to speak first, giving a Commission perspective, and then on the need to talk to the need to revise the merger guidelines. Having got that, we're going to try and throw in what I suspect may be a bit more radical perspectives from Hilary on my right, and Yanis, who can always be relied on to do that, on my far left. Then we're going to hear some what I would call words of caution. How we're going to get the balance right from Vanessa, my far left there, and from Andreas on my middle right. And then we'll circle back to two other competition officials who are here. We normally say wear various hats. We have Wolf on the end, and we have Griet here. Now, that's a very crude summary, because everybody, in reality, has got nuanced views, and I don't want to suggest that Yanis is just in the Wild West, and that Danielle isn't sensitive to the wider social issues. So with that, I'm going to pass on to Danielle. Danielle.
No, thanks a lot. I think it's a very interesting forum to be in at this momentous time. The public consultation was launched a month ago, and the public interest test is a very interesting debate. So I look forward to the discussion and to any ideas that are here. I mean, even if we may have taken an approach that, well, actually, let me defend it a bit. Some people considered it a bit of a traditional approach. Some others said that it was a revolutionary approach. So I think we may have tried to enter this debate with something new. Why are we reviewing the merger guidelines? Everybody, I think, is aware of the broader policy context in terms of what were the political guidelines of the current Commission about competitiveness and about reviewing all the tools that the EU operates in the view of achieving a more competitive European economy. And one of them was reviewing the EU merger guidelines with the idea that it should take into account the changed landscape in terms of the need of European companies to scale up in the view of global competition, of resilience consideration, the change of political environment, and a number of others. Now, underpinning those interests that can be what you would call some broader policy interests. And the idea was also, our guidelines date back from 2004 and 2008. Obviously, these guidelines were based on, we continue to believe that they were based on sound economics, but actually the economic landscape that they applied to has radically changed. I mean, we could not foresee in 2004, the digital economy as we know it today. I mean, I didn't own a mobile phone, a smartphone in 2004. I don't want to go down the examples, but we have this gig running in my team, like where were you in 2004, to just remind ourselves. So, when these rules were adopted, what our economies were like. And I think that the idea is that there are some phenomena that affect the markets and the functioning of EU markets as they happen today that we don't capture or we don't fully capture. It's not that we have not tried. There have been cases where some of the broader policy concern, I would describe them, surfaced. The Commission has started to do cases that dealt more with innovation. The Commission started to do cases that had a specific sustainability angle. The Commission started to do cases that now also had to face certain indirectly defense readiness questions. I think when we did these cases, we relied on the guidelines to a point, we relied on the principles that were in the guidelines, but we had to apply it in a context that was not necessarily defined to be used in those circumstances. So we advanced our thinking on a number of issues, and I think what this shows is that there's a lot of developments that we have tried to address on a case-by-case basis, but that we need to stop and think about in a more holistic fashion. That is why we put up for review both the horizontal and the non-horizontal merger guidelines. There's a public consultation running until the 3rd of September that's both on a general set of topics and, as Yannis mentioned before, also on 7 key topics. And that's where it gets interesting for today's discussion, where we try to lay out some of the current challenges that affect the EU economy and to frame them in the debate as potentially something that competition has to deal with. And then there are questions for stakeholders in each of those topics. Why do I say that we frame them? I think that the most important thing that is there in the papers that we put out is that we acknowledge specifically that there are certain public policies that competition law can help achieve, but we specify indirectly. So in competition enforcement, there is a lot of things that you can do when you look at the market, but I think that you need to stay with market realities and try to apply your framework in a predictable, fair and impartial manner in line with our legal mandate, which is not going to be reviewed. We're not going to review the merger regulation. But we think that what experience has shown on the enforcement in the past, at least 5, if not 10 years, is that what we do, even if it's just in line with the legal mandate, can achieve broader policy objectives. And one of the papers that is most, I think, accomplished, is the one on sustainability and decarbonization. Most accomplished because, you have something of a broader public interest that deserves a full paper for itself only. Because this is where we have had more experience. And we had more experience of that. Some people may argue because the last commission in the past 5 years decided that sustainability was now a goal and we need to try to take sustainability cases and enforcing sustainable cases with the sustainability angle. But I think that, on the contrary, this is something that happened because there was a broader drive of regulators, not only here in Brussels, but in member states to try to achieve certain sustainability goals. And in order to achieve those, the industry started to transform. And as the industry transformed, consumers started to decide that they wanted to have certain products that have a more sustainable footprint. And for consumers, I also mean intermediate users such as SMEs that have to use a product and they want to certify it when they sell it to a final consumer. So when this happens in our industry, that's an economic reality, and it's only normal that we enforce, we try to find questions and a market landscape that has changed. Now, my only conflict of interest is that I come from basic industries and I've done all the basic industries cases, so that I tend to like them a lot. And I think that the biggest development of sustainability have happened in manufacturing, because, this is indirectly linked to sustainability, but it's where, if you look at the decision in any case concerning aluminium, steel, copper, like from 10 years ago. And the ones that we have adopted in the past 10 years, you will find a very different framework of analysis. We apply the guidelines, but when we look at the quality of the products, when we look at certain impacts on choice of customers, when we look at certain other plain vanilla competition parameters, there are some very sustainability loaded concepts that we apply, not because we want to politically, but because this is what the market is achieving. And the same applies to other goals that we have addressed in another paper, which pertain to certain other public interests, one of which, the most prominent of which in the current debate, is defense. If you've seen the recent defense omnibus adopted by the Commission, there's a clear mention of the fact that the defense readiness of the European industry will be something that will be kept into account in the review of the merger guidelines, and it's something that is already there. And this is also one thing that we address in these consultation papers. Why? Because you can expect that, based on the announcement on what's happening at member state level, there will be an increase in spending, there will be some transformational deals for this industrial landscape, and at the same time, the public procurement of the member state will have to go out on these markets and procure in ways that probably will be different than the past. In that context, I think, yes, we have rules which are solid, but I think we need to specify how in this context we apply it, because this industry will face a different market reality. The biggest novelty, if I can, in the paper, however, was the explicit acknowledgement, and in the reform we want to talk expressly about the labor impact of mergers. And I think that there's a separate panel on that, so I will not dwell on that too much, but I think that it's a recognition that, from the perspective in which we approach it, the labor market is itself a market, which has rules under which it functions, which are potentially different from markets where you consume goods or services, which deserve maybe some specific thinking. And that is why, when we opened the public consultation, we decided that this would also be a topic for discussion. So overall, I think that, not to try to answer conclusively your initial question, but to give a bit of the perspective that we're trying to take, the approach from which we have launched this reform is to basically say, we are aware that we are in a space where there are increasing calls for other public policy interests to be taken into account when we look at mergers. Yet, I think that we need to remind ourselves that, when we act in the European interest, our constituents, which are citizens and member states, gave us these powers to review mergers for a specific objective that they enshrine in the law. And I think that it is true that it's important to keep these other interests into account. I mean, I know we cannot associate weather with climate, but the planet is burning, you can see it today. But at the same time, is that the task of competition regulators stand alone in the performance of their duties? I think there are certain broader policy interests, but when you have to reconcile them, that's a political choice you make. And I think that personally, when I review cases, I don't want to be faced with that political choices. Not because I don't have a political opinion about many things, on the contrary, but because I don't think it's my mandate to make that judgment call. It's somebody else, and it's a matter of accountability. So the approach that we have taken is that if these broader societal challenges, if these broader public interests translate into market realities, then they will surface in our analysis, and we need clear rules to address them. But if they're just objectives, then it's somebody else's job to enforce those objectives in the regulatory sphere. And I will stop here.
Thanks very much, Daniele. Now, that raises a number of questions in my mind, but I'm going to hold them. And when I realised that what I forgot to say, something important in my introduction, I mentioned the short addresses from our speakers, but our subsequent speakers have been asked to speak for 5 minutes, because we want to have at least half an hour for wider discussion amongst ourselves and with you guys. So please think of your questions. So next up is Hilary.
Thank you.
Over to you.
Okay, thank you very much. So thank you very much, Daniele, for that. And So the Balanced Economy Project is a civil society organisation that looks at tackling the harmful effects of economic power. And so with that in mind, it won't be any surprise to hear me say that there is, of course, a growing expectation from market participants, from consumers, from civil society, from citizens, that merger control should really pursue other objectives beyond, but also alongside the core economic goal and consumer welfare standard. And this is about adding back in the element of social policy to competition law, which is a discussion that takes place in antitrust just as it does in mergers. But there's obviously a big pushback against this, and I've seen some interesting and potentially sort of hysterical titles about, are competition authorities planning to rule the world? And I mean, I think that's a little dramatic. But the fact of the matter is it is an evolutionary process, and it's about responding to market dynamics. It's clear that there's increasing concentration, and that corporate power can and has led to big risks for society. And so within this, it's what can merger regulation do, and how do we adjust these tools to credibly counter market power? And so the backdrop of this is about the importance of regulation pushing the boundaries to tackle these harmful practices. It's an evolving landscape. We've heard just last week that the Dutch Competition Authority had a consideration of the effects of a merger in relation to media plurality. It's not new, as we've heard, that there are many jurisdictions where public interest features somewhere. And the question, I think, is about a model and about institutional setting. And can we argue that the consumer welfare test, and I don't doubt that my fellow panelists will say that it is indeed the most appropriate and unique lens through which to assess merger transactions? But I ask, is it really? Because there's an element of, whilst you can expand and have a broader view of consumer welfare, it does run somewhat counter to this view that we need clarity and a clear set of prescribed public interest considerations. And the risk, I think, is that if we don't tackle this question head on and we push it to let someone else do it, then you're going to face the risk of political interests inserting themselves into these discussions. And we can't be blinkered to this. It's better, I think, to have a careful consideration and of a model and a careful consideration of who is best placed to do that, rather than simply dismissing it as nothing to see here. And it's not about overextension of competition authorities' mandates into other regulatory areas. There are clearly rules around labour, around environmental regulations, defence, etc. And nor is it pursuing public interest in an overzealous manner. Because let's face it, if that is done, frankly, competition authorities run the risk of damaging those whose interests that they seek to protect. So from my perspective, the question is how. And I think the example of the South African competition regime in its first incarnation, and I stress that, is a recognition of prescribing a specific set of public interest criteria, an exhaustive list. And prescribing as well that public interest considerations have to be merger specific, and they have to be substantial. And any conditions that are imposed in relation to clearing a merger on the basis of public interest considerations need to be reasonable and proportionate to the merger-specific effect, which has been identified by the Competition Authority. And so the onus is really just pushing back. It's on the merging parties to be able to demonstrate that, on balance, their transaction can be justified on public interest grounds. And how do you do this? And you do this, I think, by examining public interest grounds in a public hearing by the decision maker through the prism of competition evaluation. And that means public interest is then incorporated into competition analysis, and it ensures that that competition evaluation is given the weight that it warrants. It's not considering public interest in isolation, and if you look at if you look, for example, at the South African experience, again, sort of in its early incarnation, there were few, in fact, I think no outright prohibitions of mergers on public interest grounds only. And this means that in order to have this in a public hearing, it means that you need to have, it gives the relevant stakeholders the ability to participate. And this obviously means that there need to be various procedural mechanisms to ensure that strict time frames so that things are not dragged out on purpose. But it provides for the accessibility of stakeholders in the merger process, which I think is something that can only be welcomed. And I personally think that having a competition decision maker do the balance between competition and public interest considerations is not unreasonable. It's totally common practice for mergers to be subject to multiple different criteria and decision makers. You only have to think of mergers listed on the stock exchange, or indeed those where it has licensing conditions, for example, in telecoms. It's a difficult balance, yes. But as with the application of all competition tests, it's not mechanical or mathematical. If it were, most competition authorities could be replaced by AI. And it requires like competition analysis, a predictable exercise on which, based on available information. And there is the ability, just as there is in the development of novel or different theories of harm or existing theories of harm, to develop jurisprudence, and that takes the judgment out of the realm of pure subjectivity in relation to public interest, and in so doing provides a degree of certainty in the application of public interest considerations. Personally, I think that being done by the competition authority is better than decisions being taken by politicians who, let's face it, at best have a passing knowledge of competition considerations and often have powerful lobbies around the table as they're taking these considerations. The challenge to me is how to deal with the excessively intervention politicians, because it's there, it exists already. So I think it's something that we have to face head on. And that is done, I think, through the independence and accountability of competition authorities. It's not about elevating the place of public interest over competition and decision making. And I mean, I would, a quote just to finish from the Competition Tribunal in South Africa in the Walmart decision, which I think is rather relevant here, is our job in merger control is not to make the world a better place. It's only to prevent it from becoming worse as a result of the transaction. And I think that that is the lens through which public interest considerations should be seen in relation to merger control. Thank you.
No worse off, somebody says. Thanks, Hilary. Yanis, over to you.
Thank you, Simon. And obviously, I speak on my own personal capacity, not representing the views of the tribunal. So I think I try a little bit to focus on what exactly it means to say that eventually, we could pursue a de facto public interest standard without necessarily getting into what Daniele mentioned before, the fact that, we have a legal framework. It has a specific test. We're not discussing about the revision of merger regulation, so we need to adapt that text to the current context and challenges. And so public interest elements might be either operate as a sword or a shield, right? And I distinguish between 4 types of situations. You might have, let's say, and I will use sustainability and labor as, examples of that. So first, you might have restrictions on sustainability or labor competition as a sword, right? So you're focusing on that. So there's a restriction of competition that has effects. And by restriction of competition, I mean the process of competition, or the very Georg Simmel's definition of competition, right? So really like the 19th, 20th century definition of competition, which is the fact that you have two parties that are competing in order to get attention or resources from a third party. This the tertius gaudens, as actually Simmel calls it, and that is basically what competition is, right? So in that sense, I'm not equating restriction of competition to restriction of economic efficiency or restriction of consumer welfare. I take it like as a separate thing, right? So thinking about that, you have four situations: restriction of sustainability or labor competition, which are as assured. Then you have labor or sustainability competition impact that might be a counterindication that there's no restriction of competition by object or effect in the context of Article 101, Paragraph 1. And eventually, you might say also in the context of merger control. Labor benefits or sustainability benefits as a justification of a significant impediment of effective competition, to the extent that this, that's kind of the justification issue. And fourthly, consumer market impact as a justification of a restriction of competition in the labor market or sustainability competition. So it's basically where in case you see that there is an effect on sustainability competition, but then, it has positive effects to the consumers, what are you doing in this context, right? So it can be, for instance, that firms will, develop agreements or, will merge, and that will reduce the power of labor, right, to get higher salaries, higher wages, and with that they will be able to reduce their prices in the consumer market. Is it something that you might take into account, right? So these are the kind of the four different types of scenarios. Now, for these scenarios to move forward, though, you need to first, understand what could be the market on which, these parameters will be taken into account, right? And unfortunately, the 2024 market definition notice, labor doesn't appear, and sustainability appears to the extent there's a parameter of competition. So you might identify that could be a restriction of competition in the sustainability competition. That could be basically sort of a short, but not necessarily for labor, right? And I will come back in a moment, and we have the separate panel. So then, looking a little bit to the question here is it possible for a competition law to protect? What is the scope of protection of competition law? Is it just consumers? Is it only harms to consumers, or it can also include harms to others, right? So, and I think this is an important question to answer, because if you say, and you answer that question saying, well, it is any restriction of competition that could harm anyone, be that consumer or be that producer or be that whatever, then the answer is that everyone has to be part of the scope of the protected scope of the law, right? In particular, merger control. We don't have necessarily any mention in merger control cases, as far as I know, about public interest. But we have, in the context of Article 102 cases, and since Tower Cast, we have basically this continuum between Article 102 and merger control. So, and looking to the 102 cases, you have Enel that basically says that the function of Article 102 is to prevent competition from being distorted to the detriment of the public interest, individual undertakings and consumers, which ensure well-being in the European Union. And you have more or less, so workers, citizens are not mentioned, but you have consumers, producers, which are examples of the public interest, right? And you have the same type of sentence in the Super League case as well as in the Google shopping case, right? Now, okay, so and the court in Enel focuses on the consumer side. And then says, it's a direct, we can be direct effect on consumers or indirect effect, harmful effect on consumers to the structure of the market. It doesn't say anything about individual undertakings, right? Which is the other thing that they mention as part of the public interest. Now, one might say, what is what is an independent individual undertaking? Maybe a self-employed could be an individual undertaking, in which case, it is protected, right? And then, how you can interpret this concept of individual undertaking. And I would say that if you really want to go for a structural interpretation of the law, and obviously bring in as guidance for the interpretation, the legal interpretation, the hermeneutics, the horizontal clauses that we have, like Article 9 for labor employment, Article 11 for 12, etc. 12 is consumers, 11 is sustainability, all right? So eventually, you might try to interpret that as being generally, broad. Because you need to integrate these horizontal clauses in the way you interpret the scope of the protected scope of the law. Now, that could be a legal argument, might succeed or not, and I'm just, not necessarily supporting it. I'm just putting it, as a kind of a challenge here. But then, you might have philosophical arguments, Usually, we focus on consumers because of philosophical arguments. And there are many different people have been, the first there's an argument that, well, that was the original intent, kind of the EU legislator. The people have gone to the archives, looking to, in particular, in Article 102, and that's something that you might say, well, it's the original intent. Secondly, it could be the fact that, it's a public choice political economy view. Consumers' lobbying is weak compared to firms' lobbying. Therefore, you need to protect the party that has the less possibility to influence the political process. Thirdly, you might say that, you might have a more philosophical kind of political philosophy argument, like John Rawls' distributive justice. This is a kind of, moral, the least advantaged members of the society. And, consumers are the least, eventually one might say, argue the least advantaged members of the society, but the workers as well are among the least advantaged members of society. And you can, the argument can basically be played in that sense. So, and I think, that's one issue that I have with how, we are closing down the various options in our interpretative approaches, having the law as it is, without necessarily changing regulation 4064, 139 2004 and 4064 89, was more or less interesting. Now, the other thing is, what happens if the interests, let's say, of the consumers and the labor workers of sustainability diverge, all right? I think that's the core issue here. And here, I think, that one issue is, first, are we only focusing on harm? Can we only focus on these intermediate harm to labor rights or to the sustainability, without necessarily bringing in that there is a harm to consumers? Because, if there's harm for both, it's fine. I think we can always address that issue through the mainstream approach and a bad effect on consumers, right? So if there's a bad effect on consumers, that is something that might lead you to block the merger or impose conditions. Now, imagine a case where you don't have anything, it's neutral with the consumers, but it affects labor or it affects sustainability only. Can we basically take care of that? I would say that, in my view, eventually yes, right? Because, as I said, there's protective scope of the law is not limited only to consumers, I feel. There's nothing that actually in the law that basically says that. And secondly, then, you might have the issue, okay, but these are different markets, because, you have a labor market, then you have a consumer product market, all right? How are you going to deal with that? Is it going to be, and I'm talking about efficiencies, I'm also talking about, you try to address what is the effect on competition. Are you going to have to look to both of them together? Do you have to look to one of them only? And here's a classic thing about, the two-sided markets type of situation, related markets type of situation, where, we usually look to each of them, but we address them through an effects analysis rather than by object analysis, right? So to the extent that, there is an impact there. But then, what happens then in case you have the situation that I started with? You have, let's say, a merger between two firms that eventually will lead to lower wages, because there will be bargaining power, concentration, they will have lower wages, or they will be able to, reduce, because of, the fact that the acquiring firm has is very, anti ESG and anti, sustainability, that will reduce the levels of sustainability, all right? And then they will, there might be a positive effect on the consumer side. So, they might basically be able to, and I don't think that's possible because rightly so the Commission mentions in the in-depth consultation document that to be able to reduce the wages and labor costs, this is a fixed cost argument, it cannot be considered as an efficiency, right? But let's imagine that, for the interest of the argument that, it is possible to do that, or sustainability is possible to take into account. So how that will be different in the context where you have like the current tests, right? And then the South African public interest tests, right? And I looked to the new guidelines of the South African Competition Commission, which you might disagree with, but I think it's quite interesting to see that the difference between the two sometimes, if we are opening up, it's not that drastic. I mean, it's a little bit, it might be, but I mean, it is, what they say in this context, I mean, and this is for labor, right? So they say the following, and I'll just have to find it, and I think people will, so they say, well, you might be able to use a public interest countervailing argument, right? And they say, where the merger is required because the firms will not be, where the merger is required because the firms will not be competitive unless they can lower their costs to be as efficient as their competitors. And this can only be achieved by employment or sustainability reduction through the merger, or where the merging parties provide substantive evidence that the merger will lead to lower prices for consumers because of the merged entity's lower cost base, and this lower cost base can only come about or is materially dependent upon the proposed employment reduction. And they accept this as a consideration to be taken into account on the firm, basically, to prove, I mean, the burden is on the firm to prove, right, that the consumer benefits is going to be there and obviously is going to justify this restriction to employment or this restriction to sustainability, right? So what I'm saying is, even in the public interest standard in the second version of the latest version of the South African Competition Commission guidelines, it is possible for the consumer benefits to be considered and to justify even a restriction on, even entrenchment, effects on labor or sustainability reduction. But it's on the firm to do that, and they need to provide substantive evidence that they will lead to lower prices for consumer because of these restrictions, right? So what I'm saying is, how different is that standard, which is a public interest standard, from the one that eventually, in case we follow a little bit this interpretative journey, which is somehow, not necessarily that I fully agree with what I said, I'm just trying to challenge a little bit, how this is going to be different, right? And how this is not also in favor of consumers to a certain extent. It takes into account consumers and eventually, values them more to the extent that it is possible to justify, the restrictions on employment because of, but then, the burden is shifted and it's on the firm to do that, right? So that's a question. I want to leave it there, and happy to discuss later.
It's interesting that's presenting the South African position as if it was sort of narrower than some of the other approaches which have been advocated. I see what you mean. Now, we've had various suggestions of things that should be included, all of which sound very good and healthy and desirable. But I have a sneaking suspicion that Vanessa's going to say, and I remember your words, be careful what you wish for. So over to you.
Thank you. Just for the sake of clarity, I do work for a consumer organisation. So a lot of speakers said a lot of really interesting things. I think in these opening remarks, I will just stick with what I was going to say, but I would love to come back on many of these points in the discussion if we can. So do I think merger review needs reform? Resoundingly, yes. Are we moving towards a de facto public interest test in EU merger control? I would reply, I hope not at EU level. For me, that would be a mistake for two reasons. First, I think we already have more or less the right framework in place to take legitimate public interest concerns into account. And second, stretching this framework for political reasons, to my mind, is fraught with danger. So let me now expand on these 2 points. So first, suggesting, as some people do, that EU competition law, including merger control, is only about price is an US version of competition law, and we have never had it in the EU. While price is important, and we have been able for a long time to take other factors into account. And let me just go through a little bit of the law, building on what other people have said. So Article 2 of the EU merger regulation requires that merger decisions, 1, maintain and develop effective competition within the common market, and 2, promote, and I quote here, the interests of the intermediate and ultimate consumers and the development of technical and economic progress, provided that it is to consumers' advantage and does not form an obstacle to competition. There is no limitation to only price in that formulation. And I think it also reflects the case law of the EU courts that Yanis and others have alluded to on the scope of EU competition law more generally. And if we look at the consultation documents, and Daniel has alluded to it as well, they set out numerous examples of sustainability factors being taken into account in merger control, same for innovation. We've also seen examples relating to plurality of the media. I think it would be useful if the revised merger guidelines could set out case law and case practice in one place. But do we need a major reinterpretation of that law? What is it really useful to add? And this brings me to my second point. I see significant dangers in broadening or politicizing merger control to take other public interest considerations into account. We already have Article 21.4, as already mentioned, and national law, in a second step, can look at public interest issues. Having said that, this is where this has been done at national level in this second step. The public interest overrules have not universally had successful outcomes, as, for example, the head of the German Competition Authority recently pointed out. Coming back up to EU level, while I can see the attraction of taking further public interest into account, I think this could be a Trojan horse for 4 reasons. First, and some people have already touched on some of these issues, but I might come at it from a slightly different angle. First, if you widen merger control to try to benefit society or the public interest, this could also harm it. Let me explain a bit why I see this risk. So let's start with clearing merger on the basis of promised investment. Arguably, some would say, in the public interest. And it does sound like an attractive idea, but is it really? As the consultation paper on competitiveness notes, market power typically reduces the incentives to invest and innovate in the long term. And how are we going to enforce a promise to invest? What if a merged company, once it's happened, refuses to invest? Are we going to undo that merger? Not a chance, I would guess. Then the result will be harmful market concentration with no positive counterweight. Now, the case for allowing mergers for investment is constantly being made by the telecoms industry, but data from third parties and telecoms regulators does not support the claim that greater market concentration through mergers leads to higher investment levels. In fact, the opposite. So if we are going to countenance such a change to merger control, it is essential to have a solid evidence base. The EU Competition Commissioner recently, and somewhat confusingly, appeared to imply that EU merger control had led to the EU losing, and I quote from the press report that I saw, the capacity to produce, the capacity to ensure jobs, the capacity to bet on innovation, and we will be impoverishing ourselves. Allegedly pointing in this connection to the solar panel and wind industries as notable examples of Europe losing out to cheap Chinese imports. Now, I may have missed something, and Daniela, feel free to correct me, but in a quick search, I did not find one EU merger in the solar and wind industries that was prohibited by the Commission. So, I'll come back to the importance of a fact base. Second problem, and others have alluded to it, while multiple interests, consumers, labour, sustainability, all of which I support, and so does the organisation I work for, while they will often be aligned in that market power can be harmful for all of them, as Yanis also mentioned, and I think then thus they can be tackled under today's merger analysis. But what if they are conflicting? How do you balance them out? And that's been discussed already, but I do wonder whether a competition authority has the democratic legitimacy to decide which factor outweighs the others. Without changing the European merger regulation, and it's not going to change, we've heard, can the Commission, through guidelines, decide that a merger which is demonstrably harmful to consumers should be allowed because it purportedly increases, say, resilience? Given the content of Article 2 that I mentioned earlier, I think that would be challengeable in court. My third reason for caution is that the requirement of weighing up different interests would also likely lead to much less legal certainty. Something on the basis of the Illumina Grail saga is unlikely to be mentioned, to be welcomed by most businesses, except those with those with excessive lobbying power may well welcome it, but I don't think that's the way that we want to go, and I'd like to come back to that point later. But for my last point, my final point, last but definitely not least, if we're going to open up merger control to public interests beyond what we have today and beyond what can come within a stricter senso competition analysis, I can't, in today's world, see this being restricted to environmental and social sustainability interests. In fact, beyond competition law, and all credit to the Executive Vice President and DG Competition here, but beyond this, the Commission is dropping sustainability policies left, right and centre. Therefore, I see a material risk that opening up this debate now will lead also to, or even only to, dubious public interest changes. And this in turn could lead to less rigorous merger control when increased market concentration levels today actually warrant greater merger control intervention. And therefore, I do say, be careful what you wish for.
Thanks very much, Vanessa. Well, we've heard from a Commission official. We've heard from, is it fair to call it an anti-monopoly group?
I think so. That's fair.
An academic and a consumer organisation representative. And now I'd like to turn to private practitioner, Andreas.
Thank you, and thanks also for the invitation. So just two comments, and I will actually not make the obvious comment, which you may have expected from a practitioner saying, including public interest concerns in merger review has obviously a terrible effect on the planning, feasibility studies, investigating whether mergers are possible. It's clear that mergers are not sandbox games. It depends a lot in the end on numbers, timelines, risks, and feasibility, and throwing in a lot of additional concerns makes that process even harder. Now you might say it's fine, then we have fewer mergers, but that assumes that mergers are bad, and I think for that there's very little evidence in that general assumption. But I have two other comments which actually tie into what some of the panelists already said. So a few years ago, when the sustainability discussion and how to include sustainability in competition law was really at its peak, one of the comments I made was, how do you limit the debate to sustainability? There's no logically coherent limitation that if you say, okay, sustainability is a legitimate ingredient of a competition law analysis, but then other public interests we leave out. And I think the debate here and the wider debate shows this, right? That we see that once you open the door up and we go outside our traditional instruments that we have in competition law analysis, merger analysis, you immediately are confronted with the question, okay, what else, right? So we know now defense readiness could be a topic, supply chain resilience could be one, although I still wonder what that actually means. Last week we heard from the Netherlands Competition Authority that media plurality is a legitimate goal, but frankly, if I consider media plurality a legitimate goal, there's no logically coherent reason to say free speech right of right-wing media is a legitimate goal. So I think that's the first challenge. Once you open it up, it's very difficult to see where the borders are and what you really expect from a competition authority. Now, you could put guardrails on this in the sense of saying, and I think this is what Hillary also started to refer to say certain public interests should be part of the analysis to the extent there is a clear mandate, legislative mandate like in Austria on sustainability, or a clear political mandate. And this is, I think, what the Commission also discusses, right? So clearly on sustainability, there was a clear mandate to consider this in competition and merger analysis, and the same probably for defense readiness, where you have member states and the Commission political leadership saying this needs to be part. So that could be done, but I think there's always the temptation, once you consider yourself a public interest authority, to go outside. And I think, again, last week, the merger in the Netherlands was a good example. Martijn was at least quoted by saying, we took media plurality into account because there is no other agency that can do it. We cannot do it. We don't have any mandate, but nobody else is there, and therefore we do it, right? So I think it really exposes a competition authority to risk to become the agency for social ills. And I don't think that's a way we want to go down to. Now one collateral damage of this is it's a topic I discussed with Bill Kovacic about 2 weeks ago in Japan when he spoke about a very similar topic. I think one risk there is also that this will actually undermine agency independence. Yes, like Hillary, you can say, well, but independent decision making, but once you open it up and you open it up to all kinds of interest groups, you say it's not just the parties and an evaluation of evidence, but it's essentially who shouts the loudest, perhaps gets influence on decisions. You have to wonder what that means for agency independence. So I think that's a risk. Now, we said we need to think this further through and see how strong the concern is, but I think this is something one has to keep in mind. So that's one topic. And the second comment, why perhaps I'm not saying this is all wrong, but a word of caution is that, and again, picking up on what some of the panelists already said, many of these public interest concerns involve extraordinarily hard choices. And sustainability is a great example, right? So where especially when we talk about climate change effects, it's mostly an intergenerational trade-off. So if we were to allow a merger that's on its face anti-competitive, but can be saved by some credible sustainability gains over time, essentially what we're saying is that today's consumers pay more so that our children have a better chance of having a planet with livable, that's still habitable with livable conditions, right? That's the trade-off in the basic sustainability discussion, which frankly is fine for me. I think that's the right choice. Probably the social groups represented here in this room probably think the same, but if you go out on the street and you ask people, is that the right trade-off? Depending probably also where in Brussels you ask the question, I'm not sure that you get a consistent answer on this. So this is a hard choice that you expect competition authorities to make. And I spoke with competition authorities to say, oh, no, we stay away from this. Thank you. We are in a country, EU member state, where right-wing populist parties are already very strong. The last thing we want to do is the competition authority getting involved in a debate whether we sort of, okay, let's call it, we are engaged in woke policies that cost consumers at times of increasing living costs, less affordability. We protect some sort of very glorious goals and don't care about people for the day. So these are hard choices. Now, they can be made, but I think the question is, should they really be made by competition authorities? Thank you.
Thanks, Andreas. I think Andreas has laid down a number of gauntlets for the rest of us. Yeah, that's great. Thank you. And I now turn to Wolf, I think is wearing both a competition authority sort of hat and an academic hat.
Thank you, Simon. I'm here in a personal capacity. My experience both at the university and at the competition authorities, mainly with sustainability and competition law, not with public interest tests as such. So I've had to formulate my position on that for this occasion specifically. On the principle of a public interest test in merger control, I'm very skeptical. In the Netherlands, we already have a public interest exception where the Dutch Minister of Economic Affairs can override the ACM on mergers in the public interest. This happens very rarely and has not been very successful. It does lead to questions of whether we want this type of political intervention to happen more often or not. I don't think it would improve things much to have authorities or the ACM carry out such a test, because having multiple objectives is fine if they're pointing in the same direction, but how do you balance them if they're pulling in different directions is very difficult. Authorities will then have to make political judgments, and they will therefore also be subject to more political interventions. And as business lobbyists are much stronger of force than sustainability-based lobbyists, I think we can all guess which direction that will take us in. I think a better approach is to take into account sustainability and public interest concerns as a dimension of competition where that is possible, or where there are sustainability-related efficiencies. And I think this is what happened with media plurality in the DPG-RTL merger recently decided by the ACM. So I don't think it was decided on media plurality standing on its own, but as a dimension of competition. So that's an important nuance to make. And I think this is in line with the limiting principle that has been proposed in the literature, I think specifically by Deutsche and Makis. That means taking into account other objectives and policies where they affect or are moderated by competition. And I do accept that media concentration may be a special case warranting a special exception or test. But after all, in this case, we are talking about concentration specifically when we're talking about media concentration. So instead of a public interest test, I would advocate having sustainability as a dimension of innovation and quality, also in the context of market definition and efficiencies. I would advocate extending the approach in the horizontal guidelines to efficiencies under Article 102 and the EU merger regulation, and also to extend the concept of the individual use and non-use values and collective benefits that are considered relevant for the fair share in that context. Although I would still prefer the Dutch approach, which is broader in relation to environmental damage agreements, where we don't believe there should be a requirement of full compensation within the relevant market, only an objectively appreciable advantage as a requirement. So to conclude, I would not advocate a public interest test in merger control, except possibly for media concentrations and then possibly through separate mechanisms not located with the competition authority. Thank you.
Thanks, Wolf. Extremely clear and concise. Thank you. And last and by no means least, I turn to someone from the home country here. Great.
Yes, and I will immediately pick in on what Wolf was telling about the media mergers, because at the moment we're discussing the EMFA, so the European Media Freedom Act. And I think a lot of countries are choosing their own way, and so we have our own position where we are in favor of having two procedures. So you could have one procedure of the competition authority doing everything maybe with an advice of the media regulator, which is of course potentially interesting for companies because then they only have one path to follow. But I think we are very in favor of having two procedures because first of all, I think we can capture some aspects of for example, pluralism or I think the mic, yeah, and quality degradation within the framework of competition or within the competition framework, but not all. And I think you can have conflicting circumstances where within the competition framework you cannot really judge independency or pluralism. And so therefore I think you still have yeah? It still can be very helpful to have a separate media regulator with the expertise of what is independency because I think a few weeks ago I saw a study of the European University Institute in Florence, and they have done a very huge study on what it is, media pluralism. It's huge, and there's so many difficult angles. If a small authority like ours should judge that, I think it's very tricky. So that's the first point I wanted to make. Maybe the second thing is to reverse a little bit, because I can jump in on all things that have been said, but I want to open a different angle, and that is that we can also go to highly regulated industries to check whether their competition is working sufficiently. So I think there are many highly regulated industries like finance, healthcare, with a big link to public interest, that are regulated, where you have oligopolies or even nearly monopolies, but where it's super important, I think, that we as a competition authority go to them and to maintain the small part of competition that is still there. And I think this is crucial. And what we have seen in Belgium, for example, is that there we have a little bit an issue, I think, with what the government is wanting to do already for a few years. So they have the idea, and it's a sensible idea, that hospitals should be to some extent consolidated. And I can understand, because for some types of treatments, like rare cancer treatments, it's good to have consolidation. On the other hand, now, because we were not involved in that process, and now you see that they are even hiring the thresholds. They go to 900 million euros, while the normal thresholds are 40 million euros. So you see that the government is really making a big signal, like, don't touch the mergers. And I think here it's really important to keep on telling them how important it is to maintain a sufficient degree of competition, even in these sectors. So I think this is a second area where we can absolutely make a difference. And maybe another point, a more direct issue, is privatization of cases, interventions. I think this is also something to consider. We have not a lot of means. We have only 80, 90 people. And I think also there you can have an element of public interest. To which cases are you putting your people? Are you putting people to a case of luxury goods? Or are you targeting sectors that are really vulnerable for people, or that are really important for your own country? And a very final note that struck me with an article of Eleanor Fox is opening the box of new public interest. It can be really dangerous, because if you look at a lot of mergers that we allowed, they have a huge detrimental impact already in the world. Are we going to take that also into account, or just look back and then ignore all the sustainability impact, the bad impact that some of these mergers have done, even if prices increased or quality was better?
Thanks, Greet. Now, I have more than enough questions to take up the whole of the rest of our time, but I will hold fire, and I propose to do three things. One is I think, first to turn to Danielle, are we okay there?
It's just repositioning the camera.
So I propose to pass the floor to Danielle, because I think you've had a number of things probably thrown out there, and I have to remember that the context of this seminar is indeed the reform of the merger guidelines. I then propose to turn to the floor, so please let us have any questions which you would like to put to the panel, and then I'll come back to the panel to ask any questions or make any comments on what their colleagues have said. I have to say, Danielle, You said that the merger regulation, and I understand that why, isn't going to be reformed. But, oh boy, isn't that a sort of source of regret in the sense that so many of the issues which are difficult issues we're discussing and which people get stressed over could potentially go away? Because people like me and I think Hillary would see that some of the issues where we'd like to see the Commission be able to go further could be dealt with if we were able to amend the merger regulation, whereas we're pushing at the boundaries, seeing how far we can legitimately go within it. And those who favour a more narrow interpretation of the merger regulation or competition law more generally, focusing on a narrow view of consumer welfare, wouldn't be able to say, you're stretching inappropriately competition law, because it would be explicit. And we could make it clear as whose harm, I can't remember who said it now, is it Janice or Hillary, whose harm are we concerned with? Is it just consumers, or is it wider than that? We could deal with that explicitly. And we could knock on the head once and for all this idea of the absence of democratic legitimacy, which I think is a red herring, but it comes out time and time again. So that's a bit of a waffle.
To the merger regulation reform or to this exercise?
No, sorry, this was just a bit of a preamble. I'm just saying, it does seem to me, don't we wish we could reform the merger regulation? Unfortunately, I know we're not. So we have to live in the real world, which means we've got this delicate balance. What can we properly do within the merger regulation? And the guidelines are your opportunity to do it.
Let me put a question, as Yanni said before in the philosophy, what if we could? I mean, what if we stretch the boundaries that we can do now? I mean, is that an outcome that we would want to achieve? And I think that it's very interesting, and then there's been a lot of, I've taken a lot of notes because we have to reflect a lot. I think so let me start with the deeply felt belief, then with the cynical one. I will start with the deeply felt belief, then I go to the cynical one, and then I go to the optimistic one. The deeply felt belief, while I was hearing some considerations, I was thinking, imagine that we could, and imagine that we do. I've been in the field, let's say, for a long time, and imagine, just an example, abstracting, and this draws from real examples, but abstracting, take steel, which is a pro-cyclical industry, high carbon intensive and high jobs intensive, and very jobs intensive. So imagine, clean steel maker, an electric arc furnace based, a particularly big one that acquires a decaying, old school, dying blast furnace plant, the big polluter. Now, we do an investigation, and I was making the little example that I was listing. Imagine that we find out that they want to shut it down, and we have evidence for it. So we run our case, the evidence is that they will shut that plant down. They buy it to shut it down. That's bad for jobs, that's bad for prices, but that's very good for the environment. What do we do? Second question. Imagine that we find that they want to recapitalize it, so that they have incentives because of all sorts of reasons, and keep it living and increase its production. That's good for jobs, that's good for prices, that's very bad for the environment. Now, imagine then if we find that instead they want to keep it, but they want to roll out their technology to green it. That's very good for the environment, that's good for jobs, but probably it's going to be very bad for prices. What decision do we take? And, I come from a school of, French administrative law, Montesquieu inspired, which is essentially that if you give an administration a public objective and the parameters and you say, do your job and the courts will check you, that we can do. If you give, an administration two public interests to gauge, that becomes a political choice. And, that's a different job. And from the experience where I come from, let's think about that. Also because, now I've talked about the good interests, but what if I throw in the mix that the acquirer is controlled by a Chinese entity? What if I throw in that the target supplies the army of a very big member state? Again, all of these are things that I've seen. Not all of them in the same case, but, this is just a cas de figure to illustrate my point. So I think, my deeply felt belief is that we're going in the right direction. Now, the cynical one is, I tend to, having also been in the field, I think that if we then decide to open the door, the pressure that comes the political pressure that comes in merger cases is very, very, very few times on the side of enforcing. It's many, 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 many more times on the side of not enforcing. So if you want to open it up to other public interest considerations, I can name a few, but you know, which ones will prevail if we open this to a political contest? I mean, roll your dice. I mean, I'm pretty bleak about the prospects there. However, and that's where I get optimistic and I shut up later, I think that our track record demonstrates that there are credible, tangible cases and instances where these public interests are indirectly served by what we do. And maybe it's insufficient, you know, we will not fix every problem, but whenever we find a problem that we can address through our tools, we have not shied away. We have tried to go broad on a lot of issues. On innovation, I think we have, you know, let me be proud. I mean, we have the global track record on innovation enforcement. On sustainability impact, also, I think, you know, the concepts as we laid them out, I think they're, you know, the most advanced on how a merger can have an impact on sustainability in a way that can be understood under our tests. So this consultation is about, should we do more of this? Should we do it better? And I know that it will not get there in a lot of public interest, but I think it's already a very big and a generational exercise in that. So answer the consultation, let's not miss the opportunity. Let's move.
Thank you. Right. I think Danielle has illustrated why it's so difficult to be an official. Academics can pontificate. Practitioners can just push the interests of their particular client on the day, but you have to take a balanced and consistent approach insofar as you can. Now, I'd like to open it up to the floor before I come back to my colleagues. Please, gentlemen. And yeah.
Maybe give the mic, yeah. And say who you are also.
Trevor Soames. Simon, what I'm going to say is with all respect to you, because I follow you and all the good work that you've been doing on the environment, much of which I support. But what I hear from many members of the panel, including yourself, I find really quite scary. Opening the Pandora's box, be careful what you wish for. You, me, and also you, the three of us, I think are the only people in the room who have lived through and advised on, both in government and in private practice, mergers and transactions with a public interest test, the old Section 84 of the Fair Trading Act. I was in the British government at the time when we were changing those policies after the Tebbit Doctrine. All I want to say is that that public interest test resulted in all sorts of weird and wonderful mergers being referred to the Monopolies and Mergers Commission for political reasons. Lonhro, House of Fraser, Sotheby's, Taubman. Why was that referred to the MMC on a merger? The acquisition of Sotheby's by a Jewish carpet salesman who was American. No competition issues whatsoever. So my only point there is public interest tests, be careful, because you will open that up to all sorts of political interference from all sorts of member states and result in massive uncertainty and unpredictability about a system which was created in 1989. We were there when it happened. We were there, you were there as well. When the merger regulation was adopted, there was enormous pressure to have broader public interest tests. But the United Kingdom, at that time a member state of the European Economic Community, and those handful of other countries with mergers jurisdictions such as Germany, fought hard to ensure that the merger regulation only dealt with competition issues. And that is how it is at the moment. And therefore, whilst I fully support concerns about the environment and the green agenda, what I do not support is the shoehorning of competition law, or rather shoehorning of public interest and issues into competition law, an area which should remain focused on merger regulation, significant impediment to effective competition, and what all that means, as well as the other legislative provisions of the Treaty of Rome. If you want to deal with the environment, you want to deal with, God help us, employment, deal with it in other areas for Christ's sake. Don't become like South Africa. For anybody who's dealt with the South African merger authority will know what an absolute nightmare that one is. So that's not really much of a question, but rather a cri de coeur from my heart, because I was about to start writing an article, by the way, which was "Be careful what you wish for," but I'm afraid that title has been taken from me. Because I wrote it down actually before you said it. I think it's opening a Pandora's box, a box that we don't want to open.
I would make one point. I understand the concern about the Pandora's. I think we've got this one working here, haven't we?
It doesn't work.
Doesn't work. Okay, sorry. Thanks, Trevor. I think I understand your point about the Pandora's box, but I would certainly make one point in relation to those maverick referrals, because that was a politician making a decision to refer. Whereas if it was a competition authority or some other legitimate body, they would make an objective assessment as to whether or not there was or was not a public interest in play. So that was a procedural point under a maverick UK system. Can I take another question from the floor before? Question or comment from the floor, please. Uwe.
Hello, Uli Müller from Rebalance Now, a German organization. Sometimes I see the pros and cons of the debate. I sometimes wonder if we think about sustainability as something that more from this kind of shield side to say, yeah, what would it allow for if we included it? Sometimes I wonder that, and want to keep it separate from the competition angle. And my feeling or experience is that it actually has a lot, sustainability has a lot to do with concentrated economic power. And sometimes the problem is that we're not having a holistic view on that, and we keep the competition perspective too narrow, right? So we could include, I think especially when you think about, the current problem in a lot of ways is actually that we need to reduce overconsumptions, right, of public goods and so on. And when we have to deal with that and have to try to bring forward regulation in other areas that we want to deal with that, large companies have two options to deal with that. One would be to comply with that, or B would be to fight that regulation and try to avoid it and try to kind of stop the cutting back on overconsumption. And I think at that moment, concentrated economic power is a major issue that obstructs environmental policies, and that should be something that we keep in mind when we're thinking about competition and sustainability, and seems to be forgotten somehow. Because, when you look at ExxonMobil, for example, how many years have they delayed climate action or climate protection action because of the economic power that they used to delay it? And I think that is something that I'm missing a little bit from the competition debate, because also the overall competition debate is not talking about economic power as such broadly enough, in my understanding. And I think if we would do that, I think we would come also maybe at different answers, and maybe this kind of trade-offs become a little bit different, because we can actually at some points try to cut back on economic power and both be with positive effects both on the social or on the environmental side. So I think we need to discuss this a little bit deeper. And that also refers to the question of kind of agency independence at risk, the argument that was made. Well, you could say, okay, if there are political concerns, then there's a broader issue of independence. But I would say that the biggest risk for agency independence is the inequality between the authorities and concentrated large companies, right? So that's the real problem there. It's not bringing political or public interest consideration into the game. That has complexities, that's true, but I think we need to balance where the risks are.
Thank you. I think that links with 2 points that I have come up already. One is that you're talking about taking in something like sustainability into account in the competition analysis, but taking a more broader, holistic view of what is a competition issue here, in particular power. And certainly the independence point I thought was interesting because, yes, the independence issue is much more a question of the imbalance of power, and the opening up things to other bodies seems to me to be a way of helping to redress that imbalance rather than going in the opposite direction. I'll take another question or comment from the floor, please.
It's a comment and a note on the practical applications. My name's Natalie Campbell. I'm a legal consultant and I work in corporate secretariat, so I have the dubious honour of trying to adhere to whatever rules you guys come up with, and that's why I was interested to be here today. In two respects, I wanted to mention the two different respects of the idea of there being a public interest end. I don't think that that's necessary. What I wonder is there maybe a space for Europe to move back from being so interested in the minutiae of the limits that are set on the mergers of the different companies, and that to prevent people getting too strong, having too much power, like our colleague said, sort of exercising their power in order to circumvent what are regulations to try and improve ecological kind of benefits, broader ecological benefits. All of the really serious and egregious breaches of competition law that we've seen have not happened when someone has been reporting legally. They've been when people have been usurping the regulations that are already in place anyway. For example, trucks, for example, Google, those have all been when companies have been working outside of the parameters that are already in place, so they're not really adhering to the principles that are laid down. Is there maybe space for a more broad brush approach where you're looking at the overall size of a company? At the moment, I'm working in energy. And if we wanted to, we don't, we would just usurp the regulations that are going to be put into place so that my directors are, underneath a 15% or 25% shareholding limit that is placed, so that they can have board positions, shareholdings in more energy companies, in more domiciles, get more licenses, get more tax breaks. That would be the way of doing it. So maybe a more broad brush approach would be more effective on the ground for limiting the kind of idea of a super conglomerate competition kind of entity, which is what I think we try to prevent, because those already exist and they overreach their power anyway.
Yeah, we'll take one more question and then we'll pass it around. Yeah, okay. Yeah.
Maybe we'll have the opportunity to get more questions, discussion.
Okay, right. Okay, well, let's go down the table with anybody who'd like to respond to anything that has been said then in the last 5 minutes or so.
I'll kick off if you
Yep.
If you don't mind. I think overall, I see the idea that there's a bigger picture that that's the argument, you lose the forest for the trees, right? There's a bigger picture when you look at a certain interaction in a market that companies are making, and if you look at the minutiae, as you call them correctly, I mean the specific, this is the market share here, this is how we define the market, etc., you miss the tree. I think it's our job primarily to try to translate. I mean, when you speak to market participants, you get a lot of nice stories, like big picture stories. It's our job, if we do our job properly, to translate them into actual theories of harm. And then what you need from them is minutiae to demonstrate the theory of harm. Have there been cases where I believe personally there has been mergers that after even lengthy investigation we have cleared, and I've been frustrated because I had been going for the minutiae, etc., and we were losing a bigger story that was being told in the industry? Yes, there have been. At the same time, in those cases, I remind myself that, you know, as an institution, what we're doing then is that we're essentially using prosecutorial quasi-judicial powers against companies. And in a state by the rule of law, either we are able to do it with minutiae to show to a court, or we have to drop. I mean, and that's the unfortunate and also the beauty of this job. What this consultation is about is, have we missed the forest for the trees sometimes? How can we adapt our goalposts, the one that we communicate to everybody, to make sure that, you know, we can either capture things that we have not captured in the past, or that we stop being concerned with things that are not necessarily going to be a concern in the future. This is what the guidelines are for, and that's why this process is so important. This is the moment where we will redraft the rule book to use the minutiae.
Thanks. I'd like that would have been a good point to end, not missing the forest for the trees. I just want to go round the table. Wolf or Andreas, is there anything you'd like to add in response to what?
Just in response to one comment that was made, and essentially going back and supporting what Daniele just said. So yes, it's very easy to come up with this great narrative about economic power and market concentration, but it's an oversimplification at that level that doesn't provide us really any insight, and certainly not the necessary evidence that needs to be before a decision maker. So think about aircraft manufacturing. You can't really think of a more concentrated market. Duopoly with the famous Chinese competitor just around the corner, and maybe also appearing at some point. If you look at the history of aircraft manufacturing, all they have done and all they do over the last couple of years is trying to figure out how to make a more energy efficient aircraft in the next generation. That's all they do. They don't fight any regulations. There aren't any regulations. They're driven by the market to make more efficient planes. Now you can say maybe flying is bad as such, and we want a nanny state where nobody wants to fly anymore. But that's a good example where efforts to create a more a more sustainable economy come actually from a highly concentrated market. You can look at airlines, quite concentrated. All they try is to figure out how to make more sustainable fuel if they're allowed by regulators internationally. So I think this is one example supporting what Daniele said. Yes, you can have these broad societal concerns, but to make sure they actually are meaningful in a particular case, you need more than just these sort of high-level assumptions.
Are we still responding to questions from the audience, or are we commenting on each other as well? I have a couple of comments. Well, I'm not here today to defend the Dutch decision on the DPG-RTL merger, but I think I should probably repeat that here. The decision was taken because media plurality was seen as a dimension of competition. So the public interests were pointing in the same direction, which might have made it, relatively speaking, an easy case. I'd like to challenge Daniele a little bit on his example that he gave, where I think if you're looking at innovation and quality, you're always going to have the kind of triangulation that he described as being very difficult, if not impossible. So I think it's not unusual, and I don't think sustainability is such a special case in that context. I think I agreed with just about everything Vanessa said, and as far as Griet is concerned, I would say that prioritization is a mechanism that we're using at the Dutch Competition Authority deliberately to diverge a little bit from the approach that the European Commission is taking, to take some liberties with their approach. And the example that I gave on environmental damage agreements is pertinent to that.
Thank you. So I agree with the point about not missing the wood for the trees, but I'd look at it from a different angle, which is that public interest goals are there. We see them around. The politics is there anyway. And if we blinker ourselves and think that this is not being considered somewhere, there is a risk that it is looked at from a very narrow public interest, which comes back to Andreas's point about whose public interest is it? Is it today's or tomorrow's? But it is therefore looking at it from a wider public interest. And if you have independent agencies who are better able to take a step back from that, then you take out a lot of that heated debate that comes with the change of government, this, that, and everything else. And so I'd say that it's looking at it from a different angle, which is that it's public interest as support for mechanisms that governments want to achieve, and they're going to do it anyway. And therefore, it's about how we adapt those goals through public interest tests to support this as a vehicle, but not as the prescriptive tool to get there.
So making them explicit and transparent is the message I'm getting clearly from you.
No. No. Well, I think you've probably got my point that I'm concerned that opening up the merger control to public interest has the potential to weaken merger control. And I think the evidence today produced by the Commission is that we have today concentration levels far higher than in many markets, far higher than we've had before. And for me, the key thing is that merger control works and does not allow the formation of super powerful companies that can then set the political agenda that Uli was talking about. I think it risks undermining our democracy if we allow companies through lax merger control or using excuses to allow mergers to happen. I think there is a huge risk that we undermine democracy because it gives a huge amount of power to certain types of company. It is not a coincidence, I think, that the biggest amount of lobbying in this town comes from digital companies, financial services companies, energy companies, and agri-food companies. And I think we need to think about that in changing any merger control, to weaken merger control, to allow the formation of those who can consider themselves above the law, and you can probably guess who I might be referring to. I think that would be a very dangerous way to reform this regulation or its interpretation.
Maybe yes, one thing, and that comes back to your point of the telecom and the digital. I think merger control is one thing. Being creative towards cooperation agreements that could work between very big players is another option. And it's a dangerous one, and I know, but we're currently working on the rollout of the fiber networks, where we're looking at the big players who are together wanting to roll out fiber. And I think there, if you can join, or if you can think together without going to a merger, but if you can think together, how can we make it work without a permanent merger? I think this is a potential responsibility that we can also play, to be open towards entrepreneurship and to steer it in this way. So,
yeah, I want to reframe the question. I think we all agree that we focus on restrictions of competition to the extent that there's a restriction of competitive constraint, right? Either statically or dynamically. And that is having social costs. Now, I reframe the debate. Are you basically saying, those of you that are saying, oh, we shouldn't open up, that we have only to focus on some of the social costs of these restrictions of competition and ignore others? Isn't that a political choice as well? When you actually discuss about dimensions of competition, which is a little bit, isn't it not also a political choice in that context? Because for me, we're focused on the restriction of competition, all right, the restriction of competitive constraints, and then, we should obviously go against that to the extent that it has social costs. Now, the argument that you can put forward is, but this will open up the Pandora's box. We're going to have justifications and arbitrariness, etc. I don't think that will be a problem for the following reasons. First, and that could be a criticism to the existing merger control, and that's also all the discussion about innovation defense, by the way, there is an asymmetry between the shield and the sword, right? What I mean by that is an asymmetry between when you prove that there is an impediment of competition. Those that are basically have been focused on innovation, the argument has been that, well, it is difficult to come up with an innovation justification because there's this asymmetry in terms of we tend to once we have a little bit bias towards the fact that there is a restriction, and therefore we are a little bit more difficult to justify. So I don't think we're going to have, because of this asymmetry, which is inherent in the way the system works, and the balancing basically act, I don't think that opening will happen. Thirdly, following up Wolf's argument about sustainability. Well, innovation can be the same thing. Higher prices now, but innovation in the future, right? So it's the same type of choices that you are making, right? And eventually, innovation in the future might be that these could be, benefits that somehow one eventually could discount because they are coming in the future, right? But I'm saying that there's always political choice there. So and fourthly, the issue of expertise, I think Simon raised as well. I mean, we have in the Draghi report this idea that for resilience, there will be a resilience board that will somehow fit in the process, like a technocratic type of analysis rather than a political analysis. Now, how that is possible to be achieved, I'm not entirely sure, but it is a possibility. And finally, what I suggested before at the beginning was procedural devices like the shifting of the burden of proof. Usually, you don't do, how many cases would do real balancing, even in Article 113? And, that will basically raise the concern, that will address the concerns that you mentioned. Usually, things are dealt with by shifting the burden of proof. And what actually the new guidelines for the South African Authority did is basically to shift the burden of proof. And that, to a certain extent, will possibly deal with most of the difficult questions that we have to deal with in this kind of more complex type of balance.
Well, we'll have to leave the response to those to later discussion, because we need to move to panel 2, which will be looking at 2 specific issues which could be seen as public interest issues in a wider sense. That is the issues of the workers' issues and, to a lesser extent, environmental sustainability as a subset. So I'd like to thank all my panelists here and pass on to Jean-Benoit for panel 2. Thanks, guys.